Hi, I'm Angie from Inland Professional Title, and this week our video blog is going to be on the new law regarding the release of earnest money held by escrow. So the governor signed a new law. It goes into effect July 24th. It is House Bill 1730. And what has happened in the past? The purchase and sale agreement talks about the release of earnest money when a transaction is null and void and one of the parties wants out and there's no rescission signed by both parties. So the person holding the money usually wants the rescission signed by both parties, authorizing the person holding the money who is to receive that money. So it's been kind of one of those things that's been up in the air, and we have to make decisions based on the facts that are presented. And many times the holder of the money elects not to fund the money because they have both parties fighting over who should get it. So with this new House bill signed, it makes it a little bit clearer on the responsibility for the person holding the money. So there are three options that the person holding the money can take. One is to, as soon as they're notified that one party would like the earnest money back because the transaction is now null and void, they can notify the other party that they got a letter in from the purchaser or seller stating that they would like the earnest money returned to them. Or number two, they can just flat out look at the facts, decide based on the letter, and fund it to either the purchaser or seller. Or three, if they're just not sure who should be getting this earnest money back and they have no written agreement from either party, then they can interplead the money into the courts. And when they interplead the money into the courts, then it's out of the holder's hands. The money is given to the courts, and then the court has a system set up where they will analyze all the facts that come in, and then they make the final decision on who should get this earnest money back. The problem is it costs money to interplead. You know, it can be anywhere from $650 to $1,500 or even more in some cases. And when you're just having a $500 or $1,000 earnest money, it doesn't make sense. So a lot of the amount of the earnest money will come into play on this interpleading. But this House bill, it basically says you will do one of these three things. So we may be forced to interplead, and that could be the entire, if it's $1,000 earnest money, it could all go to costs. So we're hoping we can get parties to agree a little bit better on who should be getting the money, whether they're going to split it, donate it to charity if they want neither party to get it. So it's helped a little bit. It's still not exactly what we want to hear. We'd love to have that agreement signed by both parties stating exactly who gets it. That's really the ultimate best thing that could happen. But parties do disagree, and we understand how that happens, and this is going to help us a little bit in the process. Thank you for listening, and we will talk to you next week on vestings. Thank you.